as illegality, a topic in law of contract. So we are going to first define what is illegality, which laws are applicable. We are going to first see that what are the things that are considered to be illegal in contracts, in law of contract. We are going to scrutinize this topic and we understand it in depth. So if I can start, illegality, what does it mean as you hear the name illegality? Well, illegality is something that is prohibited by law. Are you seeing? Now, let's try to apply illegality in law of contract. Now, an illegal contract. What does an illegal contract mean? An illegal contract, it refers to an agreement or a promise which by its nature is prohibited by law. Are you seeing? So, any contract that it's legal, it's obviously prohibited by law. Now, that's what we are going to look at today. And the general rule is that courts will not enforce an illegal contract. If you make a contract that is illegal, the courts will not enforce it. Now, we've already started the topic. That's illegality. Are you seeing? Illegality simply means something that is prohibited by law. So meaning that any contract, if at all you do a contract that has that illegality, obviously the courts won't help you, because even according to the general rule, the court cannot enforce an illegal contract. Now, let's try to apply the relevant authorities. According to Section 18, subsection 1 of the Contracts Act, Cap 284, that's the revised edition, Cap 284, provides that a consideration or an object of an agreement is unlawful if it is forbidden by law, or it's of such nature that, if permitted, would defeat the provisions of any law, or is fraudulent, or involves or implies injury to a person or the property of another person, or is declared immoral or against public policy by court. So, when we look at illegality is basically talked about in Section 18 of the Contracts Act, the revised edition, that's Cap 284. According again to Section 18, subsection 2, it provides that an agreement whose object or consideration is unlawful is void, and no suit can be brought in respect of that agreement. Now, that's the same thing I was telling you earlier, that if at all you make an illegal contract, you cannot enforce that contract. Reason being, according even to the general rule, it states that courts will not enforce an illegal contract. You see? Now, the authority backing up the general rule, it is Section 18, subsection 2 of the Contracts Act. Now, under this topic, we have two categories where contracts can be considered illegal. The first one are contracts prohibited by law. The second category, contracts contrary to public policy. We are going to start with our first category, and the first category was contracts prohibited by law. When we talk about law, what comes into your mind? Law, basically, these are the statutes. You're looking at the statutes. For example, we are looking at the statutes made by the Parliament, and those are the Land Act, the Evidence Act, and so on, the Children's Act, and so forth. So, there are some contracts that are prohibited by these statutes. Now, there are a number of statutes that prohibit certain transactions, or what you call certain contracts. For example, when you look at Section 41, subsection 4 of the Land Act, and that is Cap 236, it provides that non-citizens are prohibited from owning milo land or freehold land. Are you seeing? So, in case a non-citizen purchases a milo land or a freehold land, that's that transaction is void and illegal. Reason being, the Land Act clearly stipulates that non-citizens are prohibited from owning milo or freehold land. When we look at section 41, subsection 1 and 3 of the Land Act, it provides that a non-citizen can only be granted a lease not exceeding 99 years. Are you seeing? So basically meaning that if at all you lease a non-citizen land and you, let me say the lease extends to, let me say, 100 years or 120 years, that transaction is also illegal. Reason being, the Land Act stipulates that non-citizen can only be granted lease not exceeding 99 years. This I can there is this famous case of mystery ama sign versus sewano wofunira kulubya, and this case is a case of 1964, appeal case number 142. Let me repeat the case. The case is mystery ama sign versus sewano wofunira kulubya. It's a case of 1964, appeal case number 142. So in this case, the respondent was an African. He was a registered proprietor of the land. He owned Milo land. So he sold this land to a non-African. After selling this land to a non-African, according to the possession of land law and the land transfer ordinance by that time, it allowed consent. There was a restriction that before selling land to a non-citizen or a non-African, you must first seek consent from the Luchiko, and also you must first seek consent from the governor. But however, the respondent, he sold the land to Mystery Ama, who was a non-African, without seeking consent from the Luchiko and the governor. And now, the court held that the appellant, as a non-African, had no right over the Milo land, reason being the consent of the governor and the consent of the Luchiko was not obtained. Are you seeing? Meaning the transaction was void, it was illegal. Reason being, they did not follow the procedures that were stipulated by the laws at that time. The laws, the possession of land law and also the land transfer ordinance at that time, they required the consent of the Luchiko and the governor before selling or transferring the land to a non-African. Are you seeing? So basically, this case simply shows that law, if at all you do anything that is contrary to the law, that contract is void. Yes, and also according to section 89, subsection 1 of the Land Act, provides that it's an offense for a non-citizen to acquire land using fraudulent means. So basically, if at all a non-citizen through fraudulent means acquire land, are you seeing? That transaction of acquiring land, it's void. Reason being, the law forbids a non-citizen to acquire land fraudulently. So meaning that if at all a non-citizen acquires land through his or her own fraudulent means, that transaction of acquiring that land is void. And also according to section 40 subsection 1 of the Land Act, also prohibits the sale, exchange and transfer of land without the consent of the spouse. So meaning that if at all a partner wants to sell or wants to mortgage the land, he must first seek the consent of the spouse. That's a requirement of the law. That's the requirement of the law. If at all he or she does not first get the consent of the spouse, then that contract or that transaction is void. Remember, we are looking at contracts prohibited by law. So this contract between these two parties, the partner to, let me say, the other spouse. Let me give an example. If at all A and B, they are married, A, without seeking consent from B, goes ahead to mortgage their land or their house, that contract is void. But however, there are always what we call exceptions. If at all a person enters into such a transaction in good faith, he or she shall have a right to claim from any person who he paid the money to. So meaning that if at all A says or mortgages land to, let me say, Z without seeking consent from B, meaning that Z has a right to claim back the money from A. Are you seeing? So basically that is it. And also I want you to note Article 33 that talks about the rights of women, whereby women have a right to own property. I want you to also note Article 34 that talks about children's rights, whereby also children, they have the rights over ownership. Also look at Article 35 that talks about rights of persons with the disabilities. Now, if at all, I repeat, if at all any transaction is made that violates any of these people's rights, the children, the women, and the disabled, that transaction is void. It's illegal. Article 33 of the 1995 Constitution, it provides for the rights of women. Article 34 of the 1995 Constitution also provides for the rights of children. Article 35 of the 1995 Constitution, it provides for the rights of persons with disability. So if at all any transaction is made in regards to ownership of property, in regards to whatsoever, but that transaction violates the rights of these three categories of people, that is the women, the children, and the persons with disabilities, that transaction is void and illegal. According to Section 2 of the Money Lenders Act, it prohibits contracts for lending money without a money lender's license. Meaning, these people who operate those business for lending money, they should have the money lender's license. If at all they operate this business without this license, then that business or that transaction is void. I have a case law. There is this case of Jumba Soita Ali versus David Salam. Jumba Solita Ali versus David Salam. This case, the plaintiff had advanced a loan from the defendant, which he failed to pay. And the court held that since the plaintiff was carrying out the business without a money lending license, as required by the Money Lenders Act, that contract between the plaintiff and the defendant is void and illegal, and it cannot be enforced by court. Remember our general rule that the courts cannot enforce illegal contracts. Since the plaintiff gave out a loan to the defendant and the plaintiff did not have the money lender's license to proceed with this business, the money advanced to the defendant cannot be enforced by the courts of law. Reason being, the plaintiff did not have the requirements to operate that business as required by the Money Lenders Act. So this is an example of contracts prohibited by law. for a person to operate the lending business, he or she must have the money lender's license. So if at all a person operates without this license, then any transaction made between these two parties is void and illegal, and this person cannot bring a cause of action to the other person for failing to pay back. Are you seeing? So basically that's it about contracts prohibited by law. Now let's look at contracts contrary to public policy as also another category of illegality. Now let's try to see these contracts contrary to public policy. Let's start with common law. At common law, a contract which was contrary to common good or public policy was held to be illegal. At common law, any contract that was contrary to common good or public policy was held to be illegal. Now that was the position at common law. Now, according to Section 18 of the Contracts Act provides that the contract is illegal if the consideration or the object is declared immoral or against public policy by court. Now, the case law underneath is a case of it's a Kenyan case of Christ for All Nations versus Apollo Insurance Company Limited. Here, the court stated that public policy covers anything that is inconsistent with the Constitution or is against the national interest or is contrary to justice and morality. So when we look at public policy, we are looking at three things. For a contract to be considered as public policy, it shouldn't be contrary to the Constitution, it shouldn't be contrary to justice and morality, and also it shouldn't be contrary to national interest. So if at all a contract is contrary to those three, that means it's contrary to public policy. Now, the examples of contracts that are contrary to public policy include the first one, the contract to commit a crime. The law does not allow a person to benefit from his or her own crime. And therefore, if at all such a crime is committed, the courts will not enforce it, will not allow that person to benefit from his own crime. Let me give an example. If at all we have two parties, we have A and B. If at all A offers to pay B, gives B money to kill Z, and B fails to fulfill the obligation, A cannot go to court to report B for having failed to fulfill the contract of killing Z. Reason being, that contract is illegal and it's contrary to public policy. And even according to our general rule, the court will not enforce a contract that is illegal. The case beneath, I have a case of Beresford versus Royal Insurance Company. Beresford versus Royal Insurance Company. The court held that relatives of the deceased person who had committed suicide could not claim £50,000 under an insurance policy. And also read also this case of Allen versus Racecourse. Allen versus Racecourse. The court held that a contract to commit an assault was illegal and void. A contract to commit an assault was illegal and void. Now that was the position of the law in the case of Allen versus Racecourse. So another example of a contract that is contrary to public policy is contracts that are sexually immoral. Any contract that involves that sexual immorality is illegal and void. We have a case of Jones versus Randall. Jones versus Randall. In this case, the court held that an immoral contract is illegal. You know, things containing about sexual immorality, it's against or contrary to public immorality. So, in regards to this case of Jones versus Randall, the court held that an immorality, any contract that is immoral, is illegal. And also, any agreement to marry a minor is also illegal and contrary to public policy. So basically, those are some of the examples of contracts that are contrary to public policy, and they are illegal and void, and they cannot be enforced by courts of law. Well, that's the end of our today's session about illegality. We've looked at what illegality means. We've looked at the authorities under illegality. We've also looked at the categories for contracts that are considered to be illegal. And the first category, we looked at contracts prohibited by law. And also we've looked at contracts contrary to public policy. So if at all you found this session interesting, please subscribe so that you do not miss out any more videos that I'll be uploading soon, and also share to your colleagues so that they can also learn and get to know and understand these contracts that are illegal. Thank you very much.